Swayam Prabha. Digital India. Educated India.
Hello, my name is Professor Avinash Dadich. I am a Professor of Law and Dean of Institute of Legal Studies and Research, GLA University, Mathura. Today, students, we are going to talk about a very emerging business aspect, that is the IPR, intellectual property. See, the point is, historically, when we started developing our businesses, we were mainly relying on the products and services itself, but gradually with the complexity of the market, few intangible properties like the patent, trademark, copyright, industrial designs, they become very important. Like for example, if I ask you what is the price of Apple phone, like your answer could be 60,000, 70,000, okay. But if I ask you what is the cost of the hardware, in that 70,000 rupees phone, the hardware cost is not more than 5 to 6,000 rupees. The remaining thing, that is the intangible, that is not like you cannot touch it, that is the patent or designs. So, you can easily see that now we are moving into an era where the intangible property has become very important in the businesses, and whether you work in any sector, you will find the importance and value of IPR. So, in today's lecture, we will talk about the introduction of IPR, especially we will deal with patent, trademark and copyright, and then we will see how people can make money out of their IPR. So, what is intellectual property? So, intellectual property is a property that arises from the human intellect. It is a product of human creation, okay. So, you need to understand what is IP. IP is basically where people are using their intellect, so suppose you are creating a new medicine, okay. So, that is a human intellect. You are writing a new book, that is a human intellect. You are creating a beautiful logo, logo for your business, or you are creating a beautiful slogan, very impressive marketing line for your company. So, everything is basically human creation. Here there is no external factor, there is no raw material or supply or machinery, it is completely the human creation. If you go back a little bit, historical aspect of IPR, in the history, like people used to write a lot of books, people had a lot of inventions, but nobody tried to create a law like IP. That in that time, before like 600 years, 700 years back, we used to believe that the knowledge belongs to everyone, because people never try to secure exclusive rights on their knowledge, inventions and intellect. However, with the development of the technology, like for example, when the printing press was invented in China and finally is reached to Europe, especially in Italy, then it became very easy to reprint the books, like suppose before that invention, if you want to create a copy of books, you have to write it down. But with the invention, now you can print maybe 100, 1000, 50,000, 1 lakh, 5 lakh, 10 lakh copies. So, now with the intellect, you can make money also. So, that was the idea. Then the people started developing this concept. Now, we need to protect humans creation. If you don't protect the human creation, then people would like to go for free riding. So, free riding is a concept, like for example, you write a book, okay, and if you don't have copyright on it, I can also copy it and give my name and sell in the market. If that is allowed, then no author will write a book, because then there is no protection of his intellectual capabilities. Same thing with the patent. If you invent something new, for the solution, for a new solution, and if the society or the law does not give you protection, then anybody can copy, change the name and start selling it, okay. You create a big brand, like for example, there are a lot of good brands in the market. When you go to market, you see the McDonald's, you see the Apple, you see Samsung, or you see so many brands. So, you recognize those companies and their values through the brand name. So if people start copying their brand name, then it will be very difficult for a customer to know who is real and who is fake. Okay. So intellectual property law is very important, not only for the protection of human creation and human intellect, but for the consumer as well as for the inventors. IP comprises two distinct forms. One is literary and artistic work, so that comes under the copyright, okay, and then industrial IPR, that is a patent and trademark, design rights, geographical indications and so many others. So first see what is the literary and artistic works. Literary and artistic work property refers to both the direct rights of the authors or creator as well as to the encompassing ancillary rights. Therefore, literary and artistic property protects work of the mind, these being original acts of the creation which express the author or creator's personality. It applies to works of the mind like they are books, painting, musical compositions, plays, movies, radio, TV program, performance and other artistic works. How they are protected? They are protected by copyright. So suppose if you write a movie, you write a script of movie, that script is protected under copyright. If suppose if you perform, you create a new form of dance, that is protected by the copyright. And what is industrial property? This photo is taken by the authority of the IP authority in India. Industrial property describes physical matter that is the product of an idea or a concept for commercial purposes. See, the idea of literary is not only to help the people to have some intellectual discussions, they can also make money, but here when we talk about the industrial IPR, their main objective is to make profit out of it. And how they are protected? Like by patented objects, by trademarks, industrial designs, trade secrets, layout designs and geographical indications. So here you can see like the Coca-Cola, then McDonald's, Orange, all these things you can easily see they are protected by the IPR. So industrial design, if you see the bottle of Coca-Cola, the way it is designed, that is also protected. No one can create the same type of bottle by selling the cold drinks. Okay. Patents, like you said, aspirin, aspirin is a medicine, so people can get patent on the particular medicine. Then trademark, like Coca-Cola, when you see the Coca-Cola written in a specific manner, you identify that yeah, this is the real Coca-Cola. Trade secrets, like you can say McDonald's, so you really don't know what is in the McDonald's, it's a trade secret. When you go to any McDonald's across the globe, you find the same taste in every McDonald's. Okay. So trade secret is there. Even in Coca-Cola they have trade secrets, so nobody know that what is in the Coca-Cola, it's a very much protected and that comes under the IPR. Geographical indications, okay, so like for example if you go and buy the Banarsi sari or any like a French champagne, so there are few products which only in a local geographical area they can be produced, they are very specific to that area, like basmati rice. So in a very specific part of India and Pakistan, basmati rice can be produced. Any other rice which is produced outside of that area cannot use the term basmati rice. Okay. So these type of things you can see they are protected under the IPR. Intellectual property right gives IP rights a protection as well as help them to exploit and control their IPR. So once you have IPR, what do you want to do? First you want to control it, that nobody should use my IPR without my consent. Second, you want to exploit your IPR, you want to make money out of your IPR because you have invested your time, your energy, your resources to maybe write a book, to write a poem or to invent something, to create a design. So when you are putting your resources, obviously you want some return, so and that return can be the money, the recognition, valuation and all these things. The exclusive right granted by state to prevent others from using, manufacturing, distributing inventions, processes, applications, new and original designs, trademarks, new plant varieties, database and artistic and literature work. such a person is known the rights owner or right holder. So, once you have that type of IPR, then you have right that an other person cannot use it, other person cannot manufacture it, they cannot distribute it without your permission. Okay. So, these type of protections are given by the IPR to the IP right holder. Nature of IPR. IPR has become an issue of wide and serious discussion with the formation of the General Agreement of Trade Related Aspects of Intellectual Property TRIPS Agreement under the Uruguay Right Agreement of the GATT, now the World Trade Organization. So, the World Trade Organization, as you know, because see the IPRs are intangible. So, you can move one, suppose like I want to copy your book, so then I can easily copy from this country to that country. There is no national boundary to confine the IPR. For tangible goods like the property, you cannot take from one country to another country easily, but for the intangible rights you can easily copy anything and move outside of that country. That is why we have created international intellectual property law that comes under the World Trade Organization, and there is a special organization called WIPO, World Intellectual Property Organization, which manages the international intellectual property rights. So, India is also part of the WTO and the TRIPS agreement and the WIPO. India is in the priority watch list of USA under special 301 system. So, India is very important country in terms of creating IPR. IPR insists on some amount of novelty or originality to gain protection. Intellectual property is a duration specific. So, all IPRs having some deadline, like they have some expiring period. So, for example, patent is only for 20 years. After 20 years, that patent or that invention will become the part of the public domain, anybody can use it. Same thing in the copyright. After the death of the author or the copyright owner, a maximum 50 years, then it will become the public authority. It does not provide a perpetual and absolute monopoly over the property. What is protected with respect to IPR is the use or value of ideas, expressed ideas. However, the bundle of rights constituting IPR is not our abstract ideas, but rather than our physical, concrete or tangible manifestation of these ideas. So, copyright is not for the ideas, like you have developed an idea, like okay, your idea is about writing a novel on romantic stories. So, that is an idea, you cannot get complete control over the ideas, you can get control only over the content. Rights under patent law includes the right to manufacture, distribute, while rights under copyright law extend to the right of distribution, publication, all of which deal with concrete embodiments of the ideas and not the abstract ideas themselves. So, types of IPR, like you can see, the first is patent, then trademark, geographical indication, industrial design, layout design, plant variety protection and copyright. So, let us start with the patent. Designed by Thomas Jefferson in 1790 to provide a brief legal monopoly to give the inventor an opportunity to get an invention into the market and recoup development cost before competitors enter the market. Patent is a monopoly right granted by the law for the exclusive use of intellectual property to one or more individual. The instrument by which such grant is known as a patent. The patent to whom a patent is granted a patentee. Okay. So, you understand, designed by Thomas Jefferson. So, the first patent law was enacted by the Thomas Jefferson, and the idea was that the inventor, the person who is inventing something, he must have the full control on that invention and recoup the development cost. Like suppose he has invested some money on it, time on it, resources, energy. So, he should get all the benefits out of that invention. Suppose you have invested 1 year of your life, 10 lakh rupees of the investment, but later on you want to see that I want to make money out of my IPR. So, then until and unless you get full control on your IPR or patent, you cannot make money. Section 2M of the Indian Patent Act 1970 defines patent as patent means a new product or process involving an inventive step and capable of industrial application. So, there are three things. One is it must be a new product or process involving an inventive step, and second, capable of industrial application. So, now try to understand the Indian patent law. Invention, as I said, that the first thing is that there has to be some invention to qualify as a patent. So, invention relates to a process or product or both, okay, involves an inventive step, be capable of industrial application, and finally a machine. Invention patentable if it is new, it is useful, not obvious, and capable of industrial application. So, these are the conditions to go for a patent under the Indian patent law. Okay. Indian Patent Act 1970 deals with grant of revocation of patent, items not patentable. So, there are few things which is not patentable, like for example, anything relating to atomic energy, that is not patentable under the Indian law, like the softwares, computer softwares, they are not patentable under Indian law. Product patent, they are patented, like you can get the patent on the final product, or you can get the patent on the process patent also, like you are getting patent on the process rather than the final product. So, if anybody is creating that product, they cannot follow your process without your consent. Okay. Patent period is the same 20 years, rights and obligations of the patentee, okay, and working of a patent, compulsory licensing and exceptions. Okay. Duration, the term of patent is 20 years from the date of filing for all types of inventions. Priority date first to file. So, you know, the patent is not for forever. You can get exclusive right on your invention is only for 20 years, and the 20-year period will start from the date of filing for all types of invention. Okay. So, once you file the patent, maybe patent will get some time, 1 year, 2 year, 3 year, but at the time of the filing of the patent, the time will start. The date of the patent is the date of the filing the application for patent. The term of patent is counted from this date only. Fee for the filing patent. The government fee for filing a patent in India is rupees 750 for individuals and 300 for the legal entities. No fee for first and second year. Renewal fee on yearly basis is required to be paid for third and 20th year for keeping the patent in force. Patent lapses if renewal fees is not paid within the prescribed period. Patent holders in India. The list of top 10 patent holders in India comprise only pharmaceutical and biotech companies. In India, 180 patents are held by Council of Scientific and Industrial Research, followed by Ranbaxy, while the top 10 patent holders across the world are IT companies. In India, no IT firms has patents. So, it is not like that they do not have patent, but compared to other international IT companies, they have very less patents. Relevant case laws. In this case, the Supreme Court held the object of patent is to encourage scientific research, new technology and industrial progress. Grant of exclusive privilege to own, use or sell the method or the product patented for a limited period stimulates new invention of commercial utility. The price of the grant of monopoly is the disclosure of the invention at the patent office, which after the expiry of the fixed period of the monopoly passes into the public domain. In this case, the Supreme Court really gave a very good observation about the reason of patent. Students, when someone says that it is a 20-year period, very long time, and someone is having dominance or complete monopoly on that particular technology, so then this really hampers the innovation process. But just try to understand the value of that particular efforts or resources or human power which someone invest on inventing new things. In the absence of that type of protection, if someone invest money, time, resources, and if he or she is not able to get the legal protection for his inventions, for his efforts and hard work, as well as risk also, we should not ignore the element of risk in the patent, because when you are doing some scientific research, you really do not know what will be the outcome. Maybe after few years you realize that there is no new invention is coming out from our scientific experiment. So, the risk element is also there, and the second element is until and unless people are making good money out of the patents and intellectual property, how they will get more incentives to invest more on the new advanced technologies. So, this is the reasoning of the patent, and another reasoning given by the Supreme Court is that this knowledge which someone is bringing in people's domain, suppose if I have some invention and if I know that I do not get any legal protection, then I will not like to disclose that scientific development to the public or to the society. I will use it for my own personal purpose. In that scenario, society will never come to know what is the scientific development in that particular area. But as per the provisions of Patent Act, after 20 years, that knowledge, that skills, invention, innovation, everything go to the public domain, and then anybody can use it. So, for example, there are so many medicines in current period where now after 20 years the pharmaceutical companies have no patent rights. So, now all generic forms, they are using those that technology, that patent and those medicines for the commercial purposes at very low rate. So, now let us move to the trademark. What is the trademark? The trademark is an object, is a mark basically, or a slogan or a sign, so that people can identify a particular company and its quality. Trademark Act 1999 defines trademark as a mark capable of being represented graphically and which is capable of distinguish the goods or services of one person from those of others, and may include shape of goods, their packaging and combination of colors. So, you need to understand what is the trademark. Here it is a very larger concept, it is not like a simple the logo, it includes so many things, and the objective is that the trademark must create a situation for the consumer so that they are capable to identify graphically a particular company's logo. So, the important thing is for any consumer is to capable to distinguish the goods or services of one person from those and others. So, suppose when you go to market, you want to buy a particular product, for example. So, how will you identify that this product belongs to that company? So, when you see the logo or something like the geographical presence of that particular company, then you rely and you trust that this product belongs to this company, and then you are ready to invest your money. But what if suppose there are same type of logo, slogans are used by different companies in the market? How will you identify that which company owns this real product? This mark includes device, brand, heading, label, ticket, name, signature, word, letter, numerical, shape of goods, packaging, combination of colors and any combination thereof. So, brand, so here when you say the mark is not only the simple logo, it includes a very large level of large number of list here, and it can be a label, it can be ticket, it can be a signature also, in some, like if you go to buy ribbon, then you see there is a signature, and through the signature you identify that this product belongs to this particular company. Brand refers to a name, term, sign, symbol or design or a combination of them intended to identify the goods or service of one seller or group of sellers and to differentiate them from those two competitors, like McDonald's for restaurants, cycle brands and all these things. Okay. So, the objective is that as a customer you must be able to distinguish one brand to another brand, that is the objective of trademark. Brand name. Brand name is that part of the brand which can be vocalized, the utterable, like the brand name you must be able to speak that name, there are few things you do not need to speak, you just visualize it, okay. Like some logos, when you see the logo Apple, you do not you visualize that logo, but if you see a brand like McDonald's, then you must be able to see this, but at the same time there are some brands where you have to vocalize also, Brand name is that part of brand which can be recognized but is not utterable, such as symbol, design or distinctive color or lettering. Device refers to pictorial representations like animals, birds, landscape, building, so there are so many companies which is represented through their these type of devices like the animal, birds, landscape, building and all these things. So, through that picture you identify that this product belongs to that particular company. Letter as a mark is the identifier created of the letter form and has its inbuilt strength of distinctiveness and individuality like the IBM, GM, IEL, BEE, 3M, etc. So, when you see IBM, then you understand that yeah, this is IBM, like you cannot create a new company like IBM. So, like for example, you see here types of trademark. So, here Coca-Cola bottle shape and the name, the Coca-Cola, here McDonald's, the symbol, and I am loving it, that is a slogan, that is also trademark. Here Orange, it's a telecommunication company in UK. So, you can see the color of this particular company, that is his trademark. Then logo type, you can see this car company, their logo is very identified, like when you see the Mercedes logo, you can easily identify that this is Mercedes. Trademark Act 1919. The Act came into effect on September 15, 2003. It replaced the Trademark and Merchandise Mark Act 1958. It extends to the whole of India. It shall come into force on such date as the central government may publish. Trademark registration, how to go for the registration? Yeah, in the patent we did not discuss about the registration process, but that is very simple in all types of intellectual property, more or less the same thing. In the patent, when you want to go for the patent, you have to submit your application to the patent authority. So, patent authorities, the headquarter is in Chennai, then there are some regional offices, and as per your reason you need to go to the patent authority and submit your patent application. So, in patent application you can submit your provisional application or complete application. Provisional application means that you have done some research and your research is under process, but you are almost about to reach to the conclusion, but everything is not so done so far. So, you do not want to lose your priority date. The priority date is a concept that before you, if someone submits the same type of technological development to the patent authority, then you will lose your scientific invention, then you cannot go for patent. Okay. So, in that scenario you can submit your provisional application, and within a reasonable period of time given by the patent authority you submit your complete application. So, the trademark agent, you can file your trademark application through patent application through the patent agent as well as the lawyers. So, once your application is submitted, then patent authority will examine your application and they will see the prior art. In the prior art condition is that first they will check whether you have invented something new or not. If that invention is already present in the society, so first obviously they will see whether it is a real or not, something more inventive step or not. If it is not, then they will ask you to submit more documents, they will ask you more questions, and finally if they are agreed, then they will issue the patent. Okay. So, this is the process for the patent application. Trademark registration, trademark and service mark are used before registration. Registration of trademark is not a compulsory requirement of the law. Okay. So, it is not, see, patent, if you do not get your patent rights from the patent authority, you cannot claim any legal protection. However, trademark and copyright, they are not compulsory to register. However, if you do registration, you get some extra legal protection from the law. The Controller General of Patents, Design and Trademark Act appointed by central government is the registrar of the trademark. A registrar of trademark shall be kept in office. Registered trademark details shall be entered into the register. Once trademark is accepted, allocated should advertise in its prescribed manner. The registration of trademark is, if valid, gives its proprietor the exclusive right to the use of that trademark in relation to the goods or services in respect of which the trademark is registered, and to obtain relief in respect of infringement of the trademark. So, that is a very important thing. When you apply for your trademark, Like suppose you have created a logo, you want to start a new startup, you education level education tech startup or fintech startup or any type of startup. So when you file your trademark application, they will ask you, okay, please tell us what type of business you will be doing or you are doing. So you will maybe give the list of businesses, okay, these 7 businesses we are doing right now, and in future we are planning to do maybe next 20 or 25 related businesses. So whatever you write in your trademark application, if you get your trademark in those areas, you will get exclusive rights. But if you miss any area, or if someone is using your trademark in some other areas which was not mentioned in your trademark application, then you cannot stop that person. Okay, so you need to be very careful while you are designing your patent trademark application. Okay, and then finally certificate will be issued by the trademark authority. Duration of and fees of trademark. Trademark is valid for 10 years from the date of application, which may be renewed for further period of 10 years on payment of the prescribed fees. Service mark trademark are reserved exclusively for the owners for the 17 years, and it can also be renewed. The government fees is 2,500 for each class of goods and services. Trademark infringement, counterfeiting and dilution. Infringement. A mark that is likely to cause confusion with a trademark already existing in the marketplace. So what is the infringement of the trademark? Suppose you have created a logo, maybe your logo is like banana, like for example, we are selling banana shakes or anything. So your logo is banana, and someone is creating the same type of logo or trying to get the same type of name also. Like for example, your company's name is Apple, the Apple is selling mobiles. So if someone tries to sell the mobile in the market with the name of Apple, so Apple and Apple, so it creates confusion in people's mind that which one is real. Okay, and so this is very common that a lot of people, they like to start their businesses with the name of very successful companies, organizations. Okay, so they want to create confusion in people's mind, and they always like to pretend that they are the real owner of that particular brand, and people should buy from them. So it creates confusion. If someone is doing it, then that is the infringement of trademark. Counterfeiting, the deliberate copying of a mark. Like you will find many fake products in market, like the fake Reebok shoes, Adidas shoes, So a lot of people, they know that people cannot buy very expensive products. So like suppose a Reebok shoes is like 10,000 rupees. So the same type of shoes in the copy, not the original one, but the copy is sold in the market for the 500 rupees. Okay, so this is called counterfeiting, and that company can take action, civil and criminal, against those people who are selling their counterfeiting product in the market. Dilution. The value of the mark is substantially reduced through competition or through the likelihood of confusion from another mark. See, the dilution is very important. So, you will find that many companies which are not protecting their trademark, and once they become very famous, a lot of people start creating the same type of name, and in a reasonable period of time, that particular trademark loses its value, and it is difficult for customers to identify that who owns what. Then they start believing that okay, this product belongs to that owner, but in reality maybe that guy is absolutely new player in the market and has no connection with your business. So one has to be very careful while they are going for trademark, while they are protecting their trademark, because business dilution, reputational dilution is a very big issue for many businesses. Offences included falsifying and falsely applying trademark, trade description, and punishable by imprisonment and fine. So sometime that you are not going to get the trademark, so you start submitting wrong document, false documents. So that can also be a civil and criminal offense. Now let us move to the copyright. So copyright is a very historical right before the trademark and the patent. As I discussed earlier, the origin of modern, or I can say the Western style of protecting the intellectual property started with the copyright. Initially it started in Italy, then it moved to France, then the UK, and then across the globe. So, copyright is a monopoly right restraining others from exercising the right which has been confirmed on the owner of copyright. It is a negative right, meaning thereby it is prohibitory in nature. It is right to prevent others from copying or reproducing the work. The object of copyright is to encourage authors, composers and artists to create original works by rewarding them the exclusive right for a specific period to reproduce the work for publishing and selling them to the public. The moral base of copyright rests in the eighth commandment that you should not steal. The idea is that if any artist, philosopher, any singer, if they are creating any artistic work, people should not steal it, so that we can survive with our good art and culture. Copyright is not a single right. It is a bundle of rights in the same work. For example, in the case of literary work, copyright consists of reproduction in the print media, the right of dramatic and cinematographic versions, the right of translation, adaptation, abridgment and the right of public performance. So, when suppose you publish a book, so then you have all the other related rights and nobody can copy your book, nobody can translate your book without your permission, or nobody can make a movie on that book without your approval. So, copyright is quite comprehensive right. Copyright consists not merely of the right of the reproduction, it also consists right to work derived from the original work. Rights like the right of public performance, the recording rights and the broadcasting rights. Such related rights are called neighboring rights. The Indian Copyright Act 1957. The Indian Copyright Act 1957 governs the system of copyright in the India. Okay. Amended in 1982, 1984, 1992, 1994 and 1999. Meaning, it is a right which grants protection to the unique expression of ideas. Okay. It is a unique expression of ideas, but at the same time, as I told you earlier, it is not protecting the ideas itself. It is an expression of idea which is protected, not the ideas itself. Okay. The term original in the copyright means that the work originated with the author. There is no requirement for novelty or uniqueness in the patent law. In the patent law, it has to be completely unique. There has to be some novelty, there has to be some inventive step. In copyright, suppose if someone has written a very nice book on war, the Indo-Pakistan war 1971. So, the topic is same, maybe the another author would like to write the same book on the same topic, the same circumstances, but with different perspective, with different language. In that scenario, it is not necessary that someone has already written a book on Indo-Pak 1971 war, so now you cannot write it. That is not the requirement under the copyright law. Copyright law protects the expression of the idea, not the idea itself. The idea is that let us write a book on 1971 Indo-Pak war. That is the idea. Nobody can get copyright on that particular idea. Compared to patent law, that particular invention is protected. Okay. Nobody can use that invention without your approval, but in copyright you need to understand it, because it is an easy law to get, like you do not need to do any inventive step. So, the idea is not protected, only expression of idea is protected. What is covered by the copyright? So, you can say books, literary, then films, then dramatic, musical, artistic and sound recording. So, all types of intellectual and artistic expressions are covered under the copyright law. What is not covered by the copyright law? That is very important, like the ideas. As I said, idea of writing a book on Indo-Pakistan 1971 war is not protected under the copyright. Facts, whatever facts they are in the society, or historical fact, political fact, economic facts, nobody can get the copyright on those facts. Recipes, like lot of recipes are available in the already in public domain, like how to make omelette, so you know exactly how to make the omelette. So, nobody can get the copyright on that particular recipe. Okay. Work lacking originality, like the phone book, if you create a phone book, you can't get the copyright. names, titles or short phrases, that is again not under the copyright. Exceptions: where a work is made by the author in the course of his employment by the proprietor of a newspaper, magazine for publication therein, such proprietor will be the first owner. So, you need to understand, when you are working with your organization or your company, okay, and company is paying you for that particular intellectual creation, in that scenario you cannot claim copyright for that right, because then the right will go to the owner. Okay. Where a photograph is taken, or a painting or a portrait drawn, or an engraving on sign film made for a consideration at the instance of any person, then such person shall be the first owner. So, suppose you are making a painting, okay, and someone is paying you for that thing, then you will not have a copyright on that particular artistic expression. Okay. So, if any paid artistic intellectual work is done, then the person who is paying, he will have the copyright or the intellectual property. When a work is made in the course of the author's employment under a contract or service or apprenticeship, the employer will be the first owner, as is very simple. Employer is paying, so he will have the copyright. Where any person has discovered any address or speech in public, the person will be the first owner of the copyright. In the case of government work, government is the first copyright always. Registration: how to do registration of the copyright? Register a copyright by completing a simple application form along with the appropriate fee. Need not send a copy of your work. It may appear with the same title, but if each work has been created independently, each will have its own copyright protection. Although the registration of copyright is not necessary, but why registration is important? That in case if someone infringes your copyright, like you say, okay, he has copied my book, he has copied my poem. So, if you have already got the copyright and that poem is with the government, so they can check, it has some evidentiary value, it has some lot of evidentiary value. Second, if you want to go for damages like the compensation, without registration you can't go for the compensation. Without registration you can only stop other parties to use your intellectual creation without your consent. But if you are looking for a compensation or damages, then you have to go for the registration. Duration of the copyright: copyright lasts for the author's lifetime plus 50 years from the end of the calendar year in which the author dies. So, it is a very long intellectual property. You can see 50 years for films and sound recording, 25 years for typographical arrangement of a published edition. Copyright protection always expires on December 31st of the last calendar year of protection. So, we have seen patent, we have seen trademark, we have seen the copyright. Okay. So, now the next question arises that what to do with these intellectual property, because you are investing your time, money, your resources, your employers are also doing the same thing. So, ultimately you want to make some money out of your intellectual property. So, how to make money out of your IPR? Because when you are having IPR, nobody can use it. So, if you want that people should use it, you want that people should sell it, then you have to transfer your technology, you have to transfer your IPR, like you have to assign your intellectual property rights to someone else, so that other person can sell it, do the commercial activity, and you get your royalty. Okay, you get some money. So, it is like a win-win situation for the both parties. Technology transfer is the process of sharing of the skills, knowledge, technologies, methods of manufacturing, sample of manufacturing and facilities among governments and other institutions to ensure the scientific and technological developments are accessible to wider range of users who can be the further develop and exploit the technology into new products, process, application, material or services. So, the objective of technology transfer is not only to make money for the owner, but what we want that other people must be able to use that technology. Maybe they can add some value, they can create some new product, maybe they can create more quality in services through your technology. That is why the law expects that people should share these intellectual property rights with other people, but obviously not free of cost, they will get some money, but the expectation is that you cannot deny everyone. If you are denying everyone and because of your denial, especially in patent, not in copyright and trademark, but in patent, if the society at large is suffering, in that scenario people can go for technology transfer agreement. In India, technology transfer is an important means by which developing countries gain access to technologies that are new to them. Okay. Without technology transfer, most of the developing countries will not get access to the new emerging technologies. Then all developed countries and the big companies, they would like to keep their technologies with themselves only. Okay. So, once you share technology with someone, you cannot get it back, it is very difficult. Okay. So, you are ready to share your technology, your invention, if you are getting something in return. Most technology transfer has been developed and developing countries through commercial technology transfer by the private sector. By opening the Indian economy, LPG, liberalization, privatization and globalization policy 1991, several Indian companies are posed for different types of finance, technical and other forms of collaborations. Though they enter with proper technology transfer, some are not successful in different regions. Technology transfer agreement. So, TTA is the core of intellectual property rights, okay, because once you start sharing your intellectual property right with other people, then it becomes a win-win situation. For you, it is good because you are making some money. Second, it is good for you because people are using your technology, you are getting more recognition, you are getting more value in the society. On the other side, the people who want to use your technology, your artistic, music, dance, all other things, even the trademark, if somebody wants to get your franchisee, like suppose like they want to use your trademark, so they want to go for the franchisee. So, that can be also one type of technology transfer. It can be purchased through indigenous or imported sources. India has opted for judicious mix of indigenous and imported technology. Okay. So, for any country, if they want to develop, they have to develop the research and development. Okay. They have to develop their technology. So, now there are two ways to get a technology. Either you create your own technology in your country, or you go and take technology from outside. Okay. So, India has decided that we will do both, So, we will bring technology from outside through the technology transfer agreement, as well as we will create our own technology. Purchase of technology is commonly called technology transfer and is generally covered by technology transfer agreement. So, if you see the technology transfer agreement, I would like to add some more values. So, there are different types of technology transfer. One, you give your complete technology to someone, like a complete license, So, you say, okay, now this for example, patent I am talking about, you say that this is my technology and I am completely transferring this technology to you. Now, you will become the owner and I will not have any legal right on it. So, that is a one part of technology. Or you can say, okay, I am giving you not exclusive, non-exclusive patent, that you can use it, but I am not transferring the ownership, I will remain the owner, just like in housing sector, when you allow someone to stay in your house as a tenant, but you do not transfer your ownership. Okay. But in tangible property like in house, you cannot allow 5 people to stay in your house, there has to be 1 or 2 family maximum in your house. But the beauty of technology transfer agreement, that you can restrict the geographical areas also, like for example, you say that okay, I am giving you this technology, but you can use this technology only in Delhi, Rajasthan, UP and Bihar and Madhya Pradesh. In south you cannot use it, like for example, I am just talking about Indian market. Or you can restrict, okay, you will use this technology only in Karnataka, not outside of Karnataka. Then you find someone else in Delhi and say, okay, now you can sell this business in 2 states. So, as per the technology transfer agreement, you can identify that who will own what. Okay, so that is a one part. So, you can choose your geographical areas. Second, in the technology transfer agreement, you can also put clauses regarding the revenue sharing model. Either you give the complete technology at one go, you get your money and you are out, you have nothing to do with the business, or you can say that okay, you will give me suppose like like 1 crore rupees in advance, and then I will get royalty on your sale. Okay, so if you sell, I will get 2%, 4%, whatever mutually agreed number. So that can be the another example of technology transfer agreement. Second, you can say I am giving you exclusive license or non-exclusive license. Exclusive license, that in this area, okay, in this domain nobody else will be able to sell the product, only you will sell the product. Okay, so you can define the boundaries of the business, geographical boundaries, okay, as well as the revenue sharing model, like it will be revenue sharing model, partnership model, or it's just like a one time sell. So we have discussed technology transfer agreement. Now I will again revise the entire PPT for your general understanding. So first thing, very quickly I will go through again, what is intellectual property rights. So IPR is a legal protection for the inventions and artistic expressions of the people. Okay, and there are two types of literary and artistic work and industrial property. And literary and artistic work like the music, dance, theater, or novel, performance, movies, they are all protected under the copyright. And industrial property like the patent, trademark, industrial design, trade secrets, layout, geographical indications, these are all the areas where we are trying to protect the industry or the corporates. Then IPR is basically an idea that the exclusive right by the state. The state grants the IPR, like no individual can get the IPR by its own, or any corporate or any individual cannot grant the IPR. It's a basically given by the state. State means the government, by the intellectual property authority in any country. However, I would like to say you one thing that is very important to understand, that there is nothing called international intellectual property law. Okay, though we have TRIPS agreement under the WTO, which basically harmonize the intellectual property law at the global level. When I say harmonize means that they set the minimum standards, like minimum standards, okay, for the patent the duration would be 20 years. So if someone want, they can keep it more than 20 but not less than 20. Okay, so TRIPS agreement is basically general understanding of the parties. However, if you want to file it suppose like the patent in India, and if you get a patent in India, you will not get the protection in other countries. So if someone is copying your patent, your copyright, or your trademark in another country where you have no registration of your IPR, you cannot stop them. Okay, so one has to be very careful while they are designing their intellectual property law strategy. They have to identify relevant markets. Like for example, if I say oil and gas sector, so in that particular sector you need to identify those countries where oil and gas protection happens. Okay, because then you will find your competitors in that area, and if you have invented something new in that particular sector, you need to go and get the patent in all those countries. Okay, so there is nothing called international patent law, international copyright, international trademark. It's all national. And the IPR, as I discussed, it's governed under the WTO and WIPO, and these are the things. So patent is the most powerful intellectual property law because most of the financial transactions, financial value is created by the patent only. Okay, so the first patent law was drafted by Thomas Jefferson in 1790, and the idea was that we need to give a brief legal monopoly, brief, and as I say again 20 years, so it's a brief monopoly to the inventor for the opportunity to create the invention. Okay, so this was the right, and then India, we enacted our Indian Patent Act in 1970, and our Indian patent law was very helpful, especially the 1970 Act was very helpful for the Indian pharmaceutical industry. So if you see the like I give you the case study, So, if you see the growth of pharmaceutical industry in India after 1947, so till 1970s or 80s, India was importing almost 90% of its pharmaceutical requirement. So, we were not producing any pharma or medicines in our country, very few medicines. Why? Because we used to have product patent regime. Okay, the product patent regime, that all multinational companies from abroad, they got the product patent in India, like suppose a particular medicine. Okay, so now you cannot create this medicine at all. Okay. So, Indian government changed their patent regime in 1970 and they introduced the process patent only. They say, okay, you can get patent on the process, but not on the product, fine. But after the 1970s, when the Indian companies were able to create generic medicines, okay, they were able to create the generic medicines, then in that scenario, the Indian pharmaceutical companies changed the entire ecosystem, and now India is not only exporting pharmaceutical medicines in other developing and poor countries like in Africa or South America or Asia. We are almost like self-reliant on the medicines. Still we are importing few medicines, but Indian law has made the pharmaceutical sector so dynamic. Because of the change of the law, they were able to fulfill the requirement of our country. And second thing that intellectual property law gives the incentive to the people to go for more innovation and inventions. So, patent we have seen, then after that we talked about the trademark law. So, in the trademark is more like the logo, sign, signature, ticket, name, anything which can create an impression in people's mind that okay, this brand belongs to this company, and you start recognizing that company through the brand only, and then you also add your value system with that particular brand. Okay. So, if someone is trying to copy someone's brand to create confusion in customers' mind, that is prohibited under the trademark law. And then finally, we talked about the copyright. Copyright is for the artistic and literary work. Okay. And this is like you can go for the copyright, but you cannot go for the patent, you cannot go for the idea. You can get copyright only on the expression of an idea. And finally, we talked about the technology transfer agreement. Okay. So, if you read your TTA very carefully, then you can understand that how technologies are being transferred from one company to another company, and how companies can get license from the other company to develop new products and new services. So, I think this is a win-win situation for the both parties if they can use each other's technology to develop their new products and services. So, I hope that this lecture has given you very good understanding of the patent law. Thank you very much.